he had some major misconducts, the major ones, I assume.
All right, pause right there. This isn't just any courtroom hearing. This is a resentencing battle decades in the making. A 1991 murder case is being reopened because the law itself has changed. The big question: does this man spend the rest of his life in prison, or does he get a second chance?
All right. Are we on the record in the Presqu'île courtroom?
We are on the record.
All right. Good afternoon, everyone. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the Presqu'île Circuit Courtroom as well as online. And I'm Judge Aaron Goth here, presiding by Zoom video from the Sheboygan courtroom. And we're here for a status conference and motion hearing.
Notice how routine this sounds, but don't let that fool you. This is the state of Michigan vs. Tommy Lee Carlson, and the prosecution is pushing for life without parole again. That's the harshest sentence possible. The defense, they're trying to shut that down before it even gets a full hearing. Bold move.
In the case of People of the State of Michigan versus Tommy Lee Carlson, it's a 1991 file. It's number 91269FC. Counsel, you want to state your appearances beginning with the people, please?
Good afternoon, Your Honor. Zachary McLennan for the people.
Good afternoon, Your Honor. Aaron Bartels from the State Appellate Defender Office on behalf of Tommy Carlson, appearing over Zoom.
And Catherine Snedeker appearing from the State Appellate Defender's Office on behalf of Tommy Carlson.
Okay, good afternoon. Now, Ms. Bartels, Ms. Snedeker, were you intending for Mr. Carlson to appear by video from the Department of Corrections for today's hearing or no?
No, Your Honor.
Okay, all right. And I understand his attendance is not required or necessary for today's hearing. I set it for a status conference so we could talk now that we do have the prosecutor's motion for a sentence of life without parole. I did receive a response from the defense indicating that they found the motion to be so lacking in merit that they believe that I should just deny it without the necessity of an evidentiary Miller hearing. So because that was the request of the defense, suppose I should hear some argument from both sides about whether the...
Here's where things get technical, but stay with me. The judge is talking about a Miller hearing that comes from the Supreme Court case Miller v. Alabama, which basically says you can't automatically sentence young offenders to life without parole. Instead, courts must consider factors like age, maturity, and potential for rehabilitation. Translation: the system has to ask, was this person beyond saving or not?
Prosecution is entitled to go forward with that full Miller hearing or not. So Mr. McLennan, it's your motion for imposition of a sentence of life without parole. What do you say as to that question?
Yes, thank you, Your Honor. We do believe that the motion for the people to seek a continued sentence of life without parole should be granted. As outlined in our motion, not only are there certain Miller factors that we believe would be not mitigating, but neutral at best. We also outlined, obviously, the heinous nature of the crime and the aggravating factors associated with that, including what occurred after the crime in terms of escape. I think that there is also a lot more discovery still to be had in this case, Your Honor, that will shed light on a path forward here as well. But I think given the heinous nature of the crime, the victims will be providing impact statements as well, Your Honor.
And here comes the prosecution's angle. Focus on how brutal the crime was. This is classic lean hard into the facts of the offense to justify the harshest punishment. But here's the tension. The law now says the crime alone isn't enough. So, which matters more, the past or who the defendant has become?
I think the motion for pursuing life without parole should be granted.
All right, thank you. And who's going to argue on behalf of defense on this question?
I will, Your Honor. And, whether the motion to reimpose life without parole should be granted really is only decided after the Miller hearing itself, which is not today. Yeah. So,
well, I'm sorry. I understood the response. I understood that you were asking this court to rule sort of peremptorily that the prosecution's not even entitled to that I should determine that on its face, their motion was so lacking in the legal standards that we should just immediately schedule this for a term of years resentencing.
Yes. I mean, the motion certainly says that. And I do believe that the prosecution's motion is lacking under the law. And I would like to respond briefly to the prosecution's statements here today.
So I understand that there's no way that today I could rule that Mr. Carlson is subject to life without parole. I totally am tracking that. But I wanted to hear from both of you about your position that the prosecutor's filing of the motion does not necessarily trigger that Miller hearing if they haven't pled certain things. So go ahead with that.
Thank you, Your Honor. Yeah, so these motions are to be particularized, and they are to specify the facts on which the prosecutor is seeking to reimpose life without parole. In the prosecution's motion, they certainly outline the circumstances of this offense, which the defense agrees is heinous. All of these cases are first-degree murder cases, and we certainly don't argue the heinousness of the offense and the tragic loss of Mr. Frazier's life. The case law has developed quite a lot in the last couple of years, though, and there is published case law in People versus Bennett that states that the heinousness of the crime is not enough to support the reimposition of life without parole, especially in the face of overwhelming rehabilitation.
This is a smart defense strategy. They're flipping the narrative. Yes, the crime was terrible, but look at the last 35 years. Minimal misconduct, steady work, rehabilitation programs. They're basically saying, Judge, whatever he was back then, he's not that person anymore, and legally? That argument carries serious weight.
Mr. Carlson has been incarcerated for 35 years. In that time, he has only incurred 17 misconducts, and only 6 of those are class 1. To put that into perspective, and I know I outlined this in my response, but to put that into perspective, the average prisoner gets about 2.52 per year. And so he has overwhelmingly less than the average. On top of that, he has participated in rehabilitative programming. He has worked throughout his incarceration. He's maintained familial connections. And so given the case law that all of the Miller factors are at worst neutral, and given the fact that the circumstances of the offense are not enough to support life without parole, and given the fact that life without parole cannot be imposed for somebody who has the capacity for rehabilitation, the law does not say someone who has been rehabilitated. It's someone who has the capacity for rehabilitation. We think that under the law, there's just no way that the law supports the reimposition of life without parole for Mr. Carlson. Now, that said, the prosecution and I have been in contact. I will be supplying him with a lot of records, a mitigation memo shortly. And so we do hope to be able to work together to resolve this file with perhaps even an agreement to a term of years. But we are, of course, still in that stage. But I do think that the law does not support going to a Miller hearing in this case.
Are you aware of, now, on the one hand, that standard about the rehabilitation, those cases, Miller itself and many of the cases are talking about then sort of somebody who's convicted of a crime now and looking forward. And so we have somebody who's an 18 or a 20-year-old offender and trying to gaze into the crystal ball and anticipate their capacity for rehabilitation. When there's these retroactive decisions that we now grab a class of offenders for older crimes, much of the guesswork is eliminated. And how they've done in prison is oftentimes going to be, if not a dispositive factor, I would imagine given heavy weight by a resentencing court. Would you agree with that?
I would.
Okay, but even with that in mind, and even understanding that on these resentencings, perhaps it's true as a practical matter that the prosecutor's burden is even more difficult to meet in many of these resentencing cases than it would be at an initial sentencing. Even if that's true, are you aware of any statute or case law or example, any precedent at all, that would allow me to deny the prosecution a full evidentiary hearing on these Miller factors and other factors?
So the case law has not been developed in that regard yet, Your Honor. All I would be pointing to is like general motion practice in Michigan, right? We have to support our motions. If we're asking the Court of Appeals, we're filing a motion to remand. We don't just file the motion and get one, right? We don't just file a motion for an evidentiary hearing and get one. We have to put forward our offer of support that is supported by fact and law, right? Here, I do not believe that the prosecution's motion is supported by the law. But as far as me being able to point you to an appellate court's decision to that effect, it hasn't developed yet, Your Honor.
Okay.
This is the turning point. The judge is essentially saying, I hear you, but show me the law, and the defense admits there's no direct precedent. That's huge, because in court arguments without legal backing, they rarely win. You can almost feel the momentum shifting right here.
All right, thank you. Anything else I need to know to understand your position on that point?
No, Your Honor.
Okay, Mr. McLennan, any rebuttal argument on the issue of whether you get an evidentiary hearing?
Your Honor, I just think that the people's motion did set forth a substantial and compelling basis for the motion to be granted to allow these proceedings to continue towards a Miller hearing where resentencing would be appropriate. Thank you, Your Honor.
All right, thank you. Well, little context for this then, just for the record. In 1992, this defendant was sentenced to life without parole for the first-degree murder of William Frazier. Defendant was 20 years old at the time of the killing. And in 2012, 20 years later, the United States Supreme Court held in Miller v. Alabama that mandatory life without parole for offenders who were under 18 at the time of the offense excuse me, was unconstitutional, cruel, and unusual punishment. About 10 years later, in 2022, in People v. Parks, the Michigan Supreme Court extended this rule to offenders who were 18 at the time of the offense. And then in April of 2025, in People v. Zarnecki and Taylor, the Michigan Supreme Court again extended this rule to offenders who were 19 or 20 years old at the time of the offense and applied it retroactively. Therefore, Mr. Carlson is entitled to be resentenced, and life without parole may only be imposed after consideration of several specific factors and is no longer mandatory in this case. If the court opts not to impose a life sentence, then the defendant must be sentenced to an indeterminate term of years, with the minimum being set by the court between 25 and 40 years, and the maximum being set by statute at 60 years. Both the prosecutor and the defense have followed the framework adopted by the legislature after the Miller decision about if that were ever to apply retroactively. And that set forth that Michigan compiled laws 769.25 and 769.25A. There's no express statutory framework for what would happen, for 18, 19, and 20-year-olds, but by analogy, both sides have applied that statutory framework, which I think is appropriate. My understanding is that's the framework that's been followed throughout the state in the wake of the Zarnecki and Taylor decision. So under that framework, the prosecution has timely filed a motion asking this court to impose a sentence of life without parole. The defense has timely filed a response in opposition to that motion. And the defense further argues today that the prosecutor's position is so devoid of merit under the circumstances of this case that we should not proceed to a full evidentiary or so-called Miller hearing, which requires a tremendous amount of expense, preparation, and docket time. But when I look at that statutory framework, MCL 769.25A, subparagraph 4B, provides that if the prosecutor files a motion seeking life without parole, quote, a hearing on the motion shall be conducted as provided in section 25 of this chapter. That section 769.25 in subparagraph 6 expressly states that if the prosecutor files a motion seeking life without parole, quote, the court shall conduct a hearing on the motion as part of the sentencing process, and further requires that the court consider all of the Miller factors as well as other relevant information. So although even whatever motion is filed, whether to grant an evidentiary hearing on that motion is generally within the discretion of the court, I don't see under that framework where I'm supposed to consider any other relevant information. I don't really see any lawful basis for me to effectively shortcut that process and deny the prosecutor's request without giving it a full hearing. So I would.
And there it is, the decision. The judge shuts down the defense's attempt to skip the hearing. Why? Because the law says if prosecutors file for life without parole, the court must hold a full hearing, no shortcuts. So now this case moves into its next phase, a high-stakes Miller hearing where everything about this man's life will be put under a microscope. So here's the question for you. After 35 years in prison, should someone still face life without parole if they've shown signs of change? Or does the severity of the original crime outweigh everything else? This is exactly the kind of legal and moral gray area that keeps cases like this so controversial and so important.
Deny any request from the defense to skip that process and just schedule it for a term of years resentencing. Absent some later, if the prosecutor withdraws their request for life without parole, then obviously we would do that. So we'll need to schedule this then. And I do want to give both sides sufficient time to exchange materials or even to conduct additional discovery. Sometimes folks need to do updated psychological assessments. There's some case law that even entitles the people to demand the same, exploring his record in prison, trying to track down victims for input, all of that. So do you know, Ms. Bartels, about how much time the defense needs to conduct the work that you need to be prepared for the hearing?
Yeah. So with it being the prosecutor's burden, right? And without knowing what they would be presenting, I can't say for certain how much time I would need. Typically, though, the defense would need at least one full day.
Oh yeah, I'm sorry, I didn't ask my question well. I didn't mean how much docket time do you need. I just mean how much time do you need between now and such a hearing, if you were to estimate?
I understand. I'm sorry for the misunderstanding. I would probably need, just given my other sentencings that I have and other hearings that I have, I think the soonest that I would be able to do for a full Miller hearing in this case would probably be the end of this calendar year, November or December.
Okay. All right. And so what I was thinking of doing is setting a deadline for exchange of witness and exhibit lists. Maybe by Monday, June 1st would be 2 months from now. First question, would that give you sufficient time, and would simultaneous filing be appropriate, or do you prefer the people to file a witness list and then the defense to file one thereafter?
It would be my preference to have the prosecutor file theirs first, just so that ours could be responsive. So that would be my preference, Your Honor.
Okay, so Mr. McLennan, do you have any objection to sequential filing of witness and exhibit lists?
No objection, Your Honor.
Would if I set a deadline for 60 days from today, so Monday, June 1st, for the prosecutor's witness and exhibit list to be filed and served, would that give you sufficient time?
Your Honor, I believe it would. The only thing that the people are a little bit unsure of with timing right now is, and I believe this is the case for many prosecutors' offices across the state dealing with this currently, is obtaining records from MDOC. Some offices have gotten those records immediately. Some have had some issues. If there's no issues, then absolutely that timeline would be totally fine. But that is the only thing I could see potentially, Your Honor, maybe being a hang-up.
And Your Honor, if I may, Judge, I have Mr. Carlson's MDOC records, and I plan to send them to the prosecution by the end of today or tomorrow. So like I said earlier, the parties really are in communication and working together in this matter. And so I will get those records to the prosecution by end of the week.
Okay.
And then, Your Honor, if that is the case, that we receive, all the records here that we're looking for, then that should be an issue, that timeline that was laid out earlier for witness exhibit list.
Okay. Well, how about we do this? I'll enter an order that would require the prosecutor to file the witness and exhibit list not later than Monday, June 1st, and the defense to file a witness and exhibit list not later than 4 weeks later, that being Monday, June 29th. And then we could come back for a Zoom status conference on my July motion docket in Presque Isle County, which is Monday, July 13. And just kind of see at that point, are we still going forward with the evidentiary hearing? And are we to a point where we can get it on the calendar for everybody? We could do that would a morning Zoom hearing for that or afternoon work better for the appellate defender office, Ms. Bartels?
If it's over Zoom, either one. If you'd like us there in person, we'd ask for the afternoon, Your Honor.
Yeah, no, Zoom is fine for the staff. Okay. I'm pretty Zoom friendly for everything except the actual
of course.
Another hearing so let's do Monday, July 13th for a status conference at 9 a.m. Zoom appearances are allowed. And again, if you do want your client to attend by Zoom, just let us know and we'll make sure that either the court or the prosecutor's office will get a video writ to the Department of Corrections. My intention, just so everybody kind of knows, I have not, our county doesn't have a lot of these. We didn't have any that were triggered by parks. I've not conducted a Miller hearing yet. This will be my first one. As I understand it, what I'm going to do is we'll have the Miller hearing, and at the conclusion of that, I'll issue an opinion order determining whether Mr. Carlson is eligible for a sentence of life without parole. and at that point, schedule it for a resentencing hearing, where then that would be on the table. But my opinion that he's eligible for it would not foreclose in imposition of a term of year sentence at the resentencing hearing. That's what I understand from talking to some judges who've done this. Does that sound consistent with the experience that you've had around the state, Ms. Bertels?
Yes, Your Honor, that sounds right. And it's been really interesting doing these all over the state. Some judges take a 5-minute recess after the Miller hearing and come back with their decision. Some judges take a couple of months to issue their decision. But then yes, we would come back for the imposition. If you were to whatever way Your Honor decides, we would come back at another date for the actual imposition of whatever the new sentence is.
Okay, all right, very good. Mr. McLennan, anything else that the people believe we need to accomplish today?
Oh, Your Honor.
Ms. Bartels, anything the defense believes we should do today?
No, Your Honor, thank you.
Okay, thank you both very much. Have a good day.
Thank you, you too.
Thank you, Judge.